Thank y'all for coming. I'd like to say thank you especially to my wife who's here and all the friends and family who have been so supportive over the last few weeks. I appreciate y'all coming out. I've received a lot of texts and calls and emails over the last week requesting a response to the so-called audit that was done, and I told everyone I would wait. I wanted to thoroughly review everything that was released before I made a statement. Prosecutor, that's what we do. And that's what I've done here today. I've had time to look at it and review the files, and I'm ready to make a statement. I'm going to read the statement because I want to make sure that I'm accurate and cover everything comprehensively. I'd like to set the record straight. The audit and many of the things that were said on TV contained lies and half-truths. For the last 9 years, I've been a prosecutor at the Smith County District Attorney's Office. In those 9 years, I have tried more homicide cases than any other Smith County prosecutor. In those 9 years, I have tried more child abuse cases than any other Smith County prosecutor. In the last 9 years, I have tried more violent felonies than any other Smith County prosecutor. I have tried and handled each case aggressively and with integrity. This is why I was asked by law enforcement to run for office. This is why I continue to have the endorsement of the Tyler Patrolmen's Association and the East Texas Fraternal Order of Police. I'm the one who's been working with law enforcement, trying their cases, and getting justice for the victims. On Friday, I requested a copy of my personnel file. Friday morning, I received it. I'll make it available for your review. I'll be providing many documents to the media for you to review so you can see that I've checked the files and I can back up everything that I'm saying. In my personnel file, you will see I have never once been reprimanded or disciplined. My file contains proof of my hard work, performance notes, including notes of thanks, letters of recommendation from the police academy, and consistent raises and promotions, including a promotion on November 27th of 2017. The audit release was not a neutral effort to report the facts. It was an unethical attempt by my opponent and Matt Bingham to influence the election. This was a calculated effort to make me appear weak on crime, and nothing could be further from the truth. Of my cases included in the release, only one of those defendants had their case outright dismissed. That was Anthony Lemons. Anthony Lemons had 2 cases. They were each dismissed because the victim died and the cases couldn't be proven without the victim. Matt Bingham signed off on one of them. The 2 dismissals are identical. They were filed on the same day. The only difference is the cause numbers and the charge. Mr. Bingham signed one of those. He didn't sign the other one. They claim this is a policy violation, even though they're identical, filed on the same day for exactly the same reasons with death certificates attached. All of the other dismissals that were included in the audit were for defendants who had multiple cases. These multiple defendants get multiple charges, and the public likely doesn't understand how these dismissals work, so I'd like to give you examples of a few of them. Let's talk about Michael Odom. Michael Odom had 7 pending felony cases. He pled to 20 years in prison on 2 cases, 25 years on another case, and the remaining 4 were dismissed. Patrick McShann. Patrick McShann had 4 felony cases. He pled to 35 years in prison on 2 cases, and the remaining 2 were dismissed. DeLonda Player. DeLonda Player had 4 felony cases. He pled to 30 years in prison on 3 cases, and 1 was dismissed. Andy Morrison had 2 felony cases. He pled to 45 years in prison, and 1 was dismissed. Gary Warren had 2 felony cases. He pled to 30 years in prison on 1 case, and the other was dismissed. As a prosecutor, you look at all the evidence on each case. Whether someone is offered prison time, probation, or jail time is dependent on the facts and circumstances in each case. You can't convict someone on a headline. If you could, we wouldn't need jury trials. The specific facts of each case are important. The accusation that has been made against me is that these dismissals were a violation of policy. At no time did I ever believe I was violating policy. When Matt Bingham went on TV before Christmas, ranting about the policies he says I broke, he was holding a copy of the December 2012 policies. I have a copy here, and I'll provide you a copy if you want one. It'll be included in the packet that we have for the media. Let me say that all employees on December 7th of 2012 were required to read this, sign it, and return it. We were not allowed under any circumstances to keep a copy for later review. The December 2012 policies have not been followed or enforced for almost 5 years. For example, one policy in here requires that prosecutors to clock in at 8 a.m., out at 5 p.m., and an hour for lunch. Not only have prosecutors not clocked in for 5 years, several prosecutors have routinely shown up well after 8, taken long lunches, and left before 5. Other policies require approval from the first assistant or the district attorney to file a motion for continuance. Hundreds, if not thousands, of motions for continuance have been filed in the last 5 years without their approval. A third policy requires approval to drop enhancement paragraphs. Every prosecutor in the last 5 years has dropped enhancement paragraphs without approval on numerous occasions. The fourth policy prohibits our investigators from transporting evidence of any kind, yet the investigators have been ordered to do just that numerous times by every prosecutor, including the district attorney and the first assistant. The policies of the DA's office have changed in writing many times since 2012. In addition to what was in writing, based on what Matt Bingham and April Sykes told us, myself and most of the other prosecutors who've worked in the DA's office believed we were authorized to reduce cases and dismiss cases if the dismissals were part of a plea in another case. I can show you one of those emails. Dated May 7th of 2013. I am writing to you to inform you of a change in office procedures beginning immediately. ADAs do not have to receive permission from the first assistant or district attorney for any plea recommendations on any case. Dismissals still need to be signed by the first assistant or district attorney on the dismissal of cases, but not on any revocations, motions for continuance, etc. We believe this, we were authorized by this and what we were told orally, we could dismiss cases if it was a part of a plea agreement, and this is clearly reflected by the numbers in the audit. Interestingly, the audit only went back to 2013. My opponent and Matt Bingham have claimed that dismissal policy has been a long-standing policy going back for decades. I wonder why they didn't pull the 2012 dismissals. When I worked there then, and according to them, the policy was in effect then. I have pulled the 2012 dismissals. Many of them were signed without countersignatures. You'll see in those dismissals that we'll provide you dismissal after dismissal without signature because it was not policy to get them countersigned. You can ask Prosecutor Jason Parrish or Whitney Tharp, two of the prosecutors that should have been listed on that audit. Let me say something on behalf of the other prosecutors that were on the list. I believe it's shameful for someone who calls himself a leader to claim that every one of his prosecutors went rogue to try to save face. These prosecutors are good lawyers who chose to make less money in order to serve this community and see justice done. As prosecutors, we believe in laws and rules. We strive to follow the rules and enforce the laws. Not a single one of those men on that list deserves to be thrown under the bus so Matt Bingham can save face for the media. I have personally prosecuted alongside Jeff Wood, Brian Giral, and the others on that list, and they should be commended for their service, not slandered on TV. I mentioned a moment ago, I've never been reprimanded or disciplined. I have been asked about a meeting in August of 2016. There was a meeting in late 2016. At that time, rumors had begun to circulate in the courthouse that I was going to run against First Assistant April Sykes in this election. April Sykes was running for office and Matt Bingham had publicly endorsed her. I was asked to meet in Matt Bingham's office at 8 a.m. one morning while I was in trial. Present for the meeting was Matt Bingham, April Sykes, Philip Smith, and Thomas Wilson. They asked me about 3 things in that meeting. First, they asked me had I agreed to speak at a training at the Children's Advocacy Center in Anderson County. I told them that I had. Second, they asked if I had said anything bad about the office while I attended a child abuse conference. I told them that I hadn't. Third, they asked if I had dismissed any cases without signatures. In response to this question, I told them I had dismissed cases without their signature, but only if it was a part of a plea deal in another case. Matt Bingham's response to me was that he was going to pull my dismissals in check. I returned to the jury trial that was waiting for me. This meeting was in August of 2016, long after DeBrett Black's first case. For over a year after that meeting, the issue was never mentioned again. After he pulled all my dismissals in 2016, I assumed if I had done something wrong, he would have told me. A reporter asked me about the memos Philip Smith, and Thomas Wilson were ordered to write about that meeting. Matt Bingham ordered them to write those memos 2 weeks ago, well over a year after that meeting. I'll ask you, if you were asked to write a memo about a meeting over a year ago, would you remember the details? I suppose that's why the two memos reflect the meeting occurred on 2 different dates. No doubt he'll claim I was disciplined, but no discipline was recorded in my personnel file. Again, I'll make my personnel file available for you to review. My opponent in Matt Bingham's plan is not limited to misconstruing my record, lying about the past, and claiming all of his prosecutors just can't follow the rules. He and my opponent intend to expose a case of mine every week or two. In fact, my opponent was going through files in Matt Bingham's office as recently as this past Friday. They're going to pick a case and release to the media portions of the facts while I'm in trial and unable to respond. Let me give you some examples. To Corey Gilliam. Excuse me. Matt Bingham claims I illegally dismissed a case after a jury verdict. He said this on TV. Understand this. He is claiming that I, a defense attorney and a district judge, broke the law in this case. The crazy thing is that if Matt Bingham wanted to know why I dismissed a case, all he had to do was walk down the hall and ask me. To Corey Gilliam had 2 cases. He had 1 case for forgery and a second for tampering with a witness. We had a jury trial on the tampering with a witness. The jury found the defendant guilty and sentencing was set off a few weeks. In those 2 weeks, the judge, the defense attorney, and I had a chance to review the record. The record showed that the conviction likely wouldn't have survived on appeal because of specific answers the witness gave at trial. What this means is if we had sentenced the defendant, the taxpayers would have to pay for a lengthy appeal process which would have overturned the conviction because of the witness's testimony. Instead of doing that, we pled to Corey Gilliam guilty to the forgery case that was still pending and dismissed the trial case. So Corey Gilliam went to prison for 8 years. There was nothing illegal about this procedure, despite Matt Bingham's false accusation against me and a district judge. The next example is Mario Solis. Mario Solis had an injury to a child case against one of his daughters and an assault family violence case against his current wife. His wife did not wish to prosecute the assault case. In 9 years, I have tried more child abuse cases than any other prosecutor in Smith County. I care about these children and getting justice for them. Mr. Solis was accused of hitting his daughter. She had a bruise on her face. In any child injury case, the most important piece of evidence is the forensic interview of the child at the Children's Advocacy Center. What the child and her sister said in this case was that her father pulled her off the bed to spank her. As he was pulling her off the bed, her face hit the bed, causing the bruise. In that interview, she never said her father hit her in the face. It is a serious and traumatic event to ask a child to testify against a parent they love. I have held the hand of many small children on the way to the witness stand in order to convict child abusers. Before you put a child through that experience, a prosecutor who cares about the children that they protect must make sure that they have sufficient evidence to take it to trial. You don't put a child through that experience if you think you're going to lose. The state must prove beyond a reasonable doubt that the parent in question is not using reasonable discipline. The state must prove beyond a reasonable doubt that the injury was not an accident. The statements of the children allowed for the possibility in this case that it could have been an accident or could have occurred during reasonable discipline. The fact that the defendant had been drinking may or may not have convinced the jury it was intentional. Because of the totality in the evidence in the case, which included the children's statement and the statement of the other children in the home, I believe the jury would either acquit the defendant or place him on probation if he was convicted. The defendant was willing to plead to probation on the family violence assault against his wife. While it's a misdemeanor charge, it can be used for enhancement in the future, and it spared the children from having to testify against their father. For Matt Bingham to criticize my handling of this case is ridiculous. Take, for example, Myra Rodriguez. Myra Rodriguez was a felony injury to a child case. It was dismissed by Matt Bingham last week, and it pled to a misdemeanor assault, just like Mario Solis. The dismissal says it's because the victim's mother didn't want the child to testify, and because the defendant passed a polygraph on self-defense. What the dismissal doesn't tell you is that even if the polygraph were admissible in court, which it isn't, Self-defense is not a legal defense to the reckless injury of an innocent third person by law. He dismissed an injury to a child case which the defendant had no defense to and pled it to a misdemeanor assault that the defendant did have a defense to. If you need another example, I would encourage you from the media to do a public information request for Amanda Julian. Amanda Julian was another injury to a child case Matt Bingham dismissed, this time for additional investigation, which for those of you that don't know means we're dismissing it and it's never coming back. I think you'll find the reports and pictures on that case from the DA's office and the sheriff's office. The last example I'll give you on this attempt to smear my reputation is Damian Mosley. Damian Mosley is currently awaiting trial for capital murder for shooting a clerk during a convenience store robbery. He was on probation for aggravated robbery when he allegedly committed capital murder. What my opponent and Matt Bingham will tell you is that I agreed to place him on that probation. What they won't tell you is why I placed him on probation. The case he was placed on probation for involved Damian Mosley and Corey Tave. Tave was the gunman, Mosley was the lookout. The gun Tave used was not a real gun, but a BB gun. Mosley was caught first by the Tyler Police Department. He confessed to helping Tave commit the robbery as well as other robberies. He told the Tyler Police Department where to find Tave, and he agreed to testify against Tave. Mosley had no criminal history at all, while Tave had been to prison for aggravated assault. Tave ultimately pled guilty and went to prison for 20 years. I offered Mosley probation after discussing his helpfulness and cooperation with Detective Dennis Matthews at the Tyler Police Department, who approved of the offer. These slanderous attacks on my record of supposed policy violations are ridiculous, and they're dirty politics at their worst. I have tried more cases than any prosecutor in this office in the last 9 years. If you need more proof of how disingenuous these claims are, let me direct you to 2 more cases. Dennis Bendy was charged with aggravated assault. His case was outright dismissed by prosecutor Richard Vance without a countersignature. Dennis Bendy later went on to commit the P.T. Cole Park murder of an innocent mother in front of her child. Richard Vance still works in our office. Matt Bingham tried the P.T. Cole Park murder, knew about the prior dismissal without a signature, and never once went on TV and ranted about how embarrassed or ashamed he was of Richard Vance. Do you know why? Because Richard Vance is a good prosecutor. He doesn't have a crystal ball. Richard made the best decision he could with the evidence he had, and he isn't responsible for the murder Dennis Bendy committed. I didn't have a crystal ball when I handled DeBrett Black. I pled him to 12 months because the victim didn't want to testify. The defendant had no prior felonies and was a 3-time deployed combat veteran, and even if we got the maximum punishment at trial, he would have been up for parole in 15 months. The difference between my plea deal and the maximum punishment was 3 guaranteed months of confinement. I followed the policies in place at the time as already demonstrated. I also notified our grand jury attorney immediately when DeBrett Black reoffended in July of 2017. I made sure they knew to have the judge increase his bond upon indictment, since the judge initially set a very low bond of $15,000. It's easy for my opponent and Matt Bingham to play Monday morning quarterback and criticize those actually doing the job. They have each done exactly the same thing. I'll give you one last example. Terrence Raybon was a violent felon with 5 prior felony convictions. Instead of prosecuting him for unlawfully possessing a firearm as a felon, Matt Bingham let Terrence Raybon out of jail and put him on probation. Do you know what Terrence Raybon did? He shot Tyler Police Officer Ken Garner 2 months after being released on probation. Let me repeat that. Matt Bingham let a 5-time convicted felon out on probation, and he shot Tyler Police Department Ken Garner, nearly killing him. The doctors were able to save Detective Gardner's life, but he still has the bullet inside of him. I'm running for district attorney because I believe in truth, justice, and aggressive prosecution with integrity. I have faithfully served the citizens of Smith County for 9 years. I'm committed to upholding the rule of law, to ensuring everyone is treated equally, and to aggressively prosecuting criminals to keep this community safe. Most of all, I'm committed to truth, transparency, and accountability. I'm committed to having clear and concise policies that every prosecutor will know. I'm proud to have the endorsement of the Tyler Patrolmen's Association and the East Texas Fraternal Order of Police, Brian Hughes, Kevin Eltype, Matt Schaefer, Cole Hefner, and others. I pledge to vigorously uphold the rule of law in our Constitution. Justice will be applied equally to everyone, regardless of race, social status, age, including elected officials. Our DA's office will have crystal clear policies, be filled with people of unquestionable integrity and professionalism, and we will cooperate with our brave law enforcement officers to protect the citizens of Smith County. Thank you all for coming. If any of y'all have questions, I'll take questions.
Following that case for quite some time, and I spoke to the victim of that case. You said she did not want to go through with the charges, and
no, that's not what I said. He had a pending assault case against someone else. That victim didn't want to prosecute that case, not the mother of the child.
Okay, right. So you have also spoken about the child and how you didn't want to put her on stand, but I spoke to the mother who says she felt that you did not protect her daughter by not putting her on the stand because she wanted the jury to know what kind of abuse they had gone through. Now, I do see that he also had priors in Reagan County.
Did he have prior convictions?
He actually did not. It was not a conviction, but
I just want to be careful that you're saying he had priors. If you're saying he had prior convictions and he didn't, that wouldn't be accurate.
Right. He had prior arrests in Reagan County.
That were dropped? Dismissed?
They were not dismissed.
They weren't?
No, he was arrested. It was not a conviction. You're correct on that. But that's not what I'm trying to ask.
I'm sorry.
Have you spoken to that mother since?
When? Since when?
Crystal, since the whole Debrett block, because she has come to light, and I think basically she's kind of trying to get an apology out of you, and I don't think you've done that.
She hasn't contacted me.
She contacted you on Facebook, and I've seen it. Also, you said the girl had a bruise on
her. Is that a question, or are you just...
No, I'm asking you. Have you reached out to her, or do you plan to reach out to her?
I did reach out to her, and she didn't respond.
Okay. And then you also said that that little girl had a bruise on her face. I think saying it was a bruise is an understatement. I've seen the pictures of that little girl, and she looked really beat up. For people who want to hear from you, or who want to know why that case was dismissed when the mother claims that she wanted that felony 10-year probation, what do you have to say to that?
I would say the bruise on the face was not caused by her father hitting her, and that was clear from the evidence in the case.
You also say that you always want to do what your victims, what is best in their interest. Do you think in that specific case, after hearing what the mother had to say afterwards, which I'm sure you have, do you still think you were protecting her to the best of your ability?
I will say that any time you have a contentious custody battle between a mother and a father, that there are lots of reasons why people want those cases aggressively prosecuted. I think we did what was just and fair in the situation.
Okay, that was my question. Thank you.
Yeah. Other questions?
Have you talked to your boss, to Mr. Bingham, about the things that you've mentioned here? Did you discuss any of the stuff that you put out earlier to your supporters with him? Have you guys had face-to-face conversations, or
can you ask one at a time?
Have you and your boss, Mr. Bingham, had face-to-face conversations about this? And I mean, you mentioned, I remember prior reporting that you had apologized for the Debrett Black issue. Have you guys had any other conversations? I mean, you work with him every day. How does this relationship?
I'll answer both of those questions. First, as far as the apology, back when, right after Thanksgiving, after Debrett Black committed murder, Mr. Bingham and I had a conversation. He explained to me that wasn't what the policy was. At that time, I thought perhaps I was confused about it. I had operated under that understanding of the policy for 5 years. I now realize I wasn't confused about it because every other prosecutor thought just like I did and was doing the same thing. So really, I think I was just being set up. Now, as far as talking since then, no, since Christmas we haven't had any conversations.
At all? And you work with him daily in the
Well,
office?
I work in the 114th District Court for him, but we don't necessarily work together.
Got it.
Any other questions? Yes, sir.
Do you feel that Mr. Bingham is supporting your opponent?
I can think of no other reason that he would task an investigator for preparing this so-called audit and letting my opponent into his office and go through files without a public information request.
Are you not aware of the acrimony when Alicia ran against Matt to take that office many years ago?
I'm aware of it.
And you still think after the nastiness that was shared during that time period, that he would support her now?
I think he was out a couple Sundays ago putting up her yard signs and her big signs on the side of the road.
So, do you think that Mario Solis's ex-wife is part of their conspiracy also?
What's that?
You think, back going to the Mario Solis case, this mother has, gone on camera and said that she doesn't think that you justifiably protected her daughter. You think she's part of this whole conspiracy against you too?
I can say that anytime we have victims who are especially involved in a contentious custody battle, they're not always happy with the result the criminal justice system gets them. It's not a perfect system. It doesn't make everybody happy. I think that we try our best to get justice in each and every case based on the evidence we have. And that's all we can do is go off the evidence we have.
That's not what I asked you. Also, the custody battle is over. She does have custody of the children. He can visit them with supervised visitation.
Are you talking about now or back when I handled the
I'm
case?
talking about now.
Okay, I'm talking about back when I handled the
But
case.
that's not what I'm asking you. I'm saying now that she is reaching out after the fact
Yes.
that you are running for DA. Do you think she's part of this whole conspiracy against you? Is that what you're saying?
No, I think she's upset with the way her case turned out. Any other questions?
So how's it working now? Are you seeking signatures? Is Bingham has told you, or it's the expectation to sign off on some of these dismissals and things, or are you continuing to handle it the way you see best?
Well, we received an email on December the 13th making it clear no dismissals whatsoever which should be filed without signature. We were also prohibited from disclosing any office documents, records, or policies to the public at that time. So since that email, no, we haven't dismissed anything. Yes, sir.
Isaac Ramirez with KETK News. Back to the Mario Solis case, Crystal Zuniga said that you said, quote, that y'all would get him on an intangible charge next time, end quote. Wouldn't you want to prosecute at that time so there wouldn't be a next time?
I disagree with that quote. That's not what I said. Other questions? Yes, ma'am.
Mr. Putman, I would like to begin speaking on behalf of the Grassroots America Board of Directors. I would like to have a copy of what you are providing for the media today, because I can tell you we are not interested in opinions. We're interested in the facts that you presented today, and we will review every one of these cases. And I am particularly interested in the Tyler police officer who's still walking around with a bullet in his back. I want to know more about that. So we will review what you provide today, and if we have additional questions, we will ask you to appear before the board.
Yes, ma'am.
Thank you.
Other questions?
I have a question. Right after the Debrett Black, I did speak to Mr. Bingham, and I really grilled him on why nothing was happening in regards to speaking with you. And he was very supportive. He said, he's my employee, and I think if he had bad character, I wouldn't have hired him. And he said, he is running unopposed right now, and so I want him to be the most prepared to take my office.
Right.
So what do you think changed between then and now, and why do you think why do you believe that he wants your opponent to win so bad when just a few months ago he was defending you on camera?
I wouldn't call what he said defending me. I think he said that he supported me because I'm the only one running, and then somebody filed to run against me. How you can work for someone for 9 years and then 40 days before a primary, all of a sudden you're the worst employee he's ever had, I don't think that's a coincidence.
Mr. Putman with the Tyler paper, and I just want to kind of caveat back on what she said. And we were told by Mr. Bingham that he supports you. He wants to keep you in the office to get you more experience up until you were elected, because that's what he actually thought was going to happen before Ms. Barkley put her name in the ring. I would disagree that there isn't support. How do you see that? I mean, he said he wants you there so he can give you the experience, especially with the capital murder cases coming up.
He said that on camera. It's not what he said privately to people inside the office.
Well, what did he say privately in the office?
That he was going to come after me, he was going to make sure my opponent had a bunch of money, and that he was going to see that my opponent won.
In the first interview you did with us, you mentioned that you weren't sure of the policy when it comes to 1245 dismissals. why did you continue to override the policy even after Bingham confronted you in August of 2016?
I don't understand your question, I'm sorry.
In the first interview you did with us, you mentioned that you were not sure of the dismissal policy. How come you continue to do dismissals even after Mr. Bingham confronted you in August of 2016?
What happened in August of 2016 is I was asked if I had dismissed any cases without signatures. And I told him that I had, but only if it was a part of a plea bargain. And what I was told in response is that he was going to check. I assumed he did check all my cases, and he never told me that I did anything wrong after that. So I had dismissed several cases when they had pled to other cases I mentioned. After those cases were pulled, I wasn't reprimanded, I wasn't disciplined, I wasn't instructed to do otherwise. I believe the policy in effect, both before and after that meeting, was that I was allowed to dismiss cases if it was a part of a plea bargain in another case. Other questions? Thank you all. Oh, sorry, go ahead.
I have a watcher here on our Facebook Live, and she's wanting to know why you will not respond to Damon Allen's widow.
I have responded to her.
Okay. She's saying you haven't. Just letting you know.
That's not accurate.
Okay.
Any other questions?
What did you say to the widow?
I have it written down. I can show it to you later. I don't have it in front of me. So. Any other questions?
How can you ensure that the victims of violent crime in Smith County can depend on you so they can get it, so there can be a conviction?
Well, I've included my trial record in the documents that I'll provide to you, and you can see over and over and over again that I have tried more cases on behalf of victims than any other prosecutor in Smith County. Law enforcement that I work with every day knows that I support them and I work hard to get justice for victims. I've done it more than any prosecutor in the last decade. That's how they can know that I'm going to do the job for them.
I do believe you had a discussion with your opponent a few weeks ago. It was a Thursday night, and you were asked if you could change anything about the district attorney's office, what would it do if you were in office? I remember you said nothing, we run pretty well right now. The only thing I would want to change is I would want to keep my prosecutors longer. Do you still feel the same way?
I don't think that's what I said, but I did say I wanted to improve prosecutor retention. That's correct. I think that we need clear policies in place. We need to support our prosecutors so that the person and the prosecutor in your court handling your case, if you're the victim, has been there a long time. We don't need someone fresh out of law school handling serious cases, somebody with 1 or 2 years experience prosecuting serious cases. We need prosecutors who have been there for years. There's other district attorneys' offices in the state where they have prosecutors who have been there 20, 30 years. We need that. We need to retain and keep those prosecutors long-term, and we've been unable to do that to this point.
No, and that is what you said the first time, but you said other than that, you said, and I have the video, I can go back and pull it for you if you'd like. You said, we run pretty well and I think we do a good job. Do you still feel the same after it has come to light that there is maybe some turmoil in the office?
I'm not denying there's turmoil in the office. What I'm saying is that list of prosecutors that was provided in the audit, they do a good job. All those prosecutors try hard to serve Smith County and the victims, and I think they should be supported and commended for what they do.
So what would you do going forward if you won the election to make sure that your office, everyone in your office was on the same page, was doing what policy is, and that something like this wouldn't turn up in the future?
Well, like I said earlier, I want clear and consistent policies. I want every prosecutor in the office to have a copy of those policies so they could review them. I also want to maintain a continual dialogue where the district attorney is involved in the docket of each court every week. They know what's happening with the cases. It's not that hard to keep track of what cases are being dismissed every week if you just have a conversation with your prosecutors.
So you're saying Matt Bingham doesn't do that now?
That's correct. Yes, ma'am.
One more question. I talked to a district attorney judge that I was given a contact to, and he told me that there's basically two types of district attorney's office. And it all involves intake of cases. And so he told me that if you intake a lot of cases that aren't probably put together well enough, you'll have a lot more dismissals on the other end. What's your take on that? Whereas if you take in cases that are put together really well, investigated really well, and the evidence is hard and concise, it helps you guys to where there won't be dismissals on the other end. Can you tell me about that?
Well, that's part of one of the things. That's one of the things I stand for is collaborating with law enforcement. I think that's valuable to have a proactive intake system where you're working with law enforcement. You're talking to them about the cases they bring you. You're educating them on what good things they're bringing you, what additional things they need to bring you. Because every case they bring you needs, if it's going to go to trial, needs to be a solid case where the public can be assured that this is going to be a conviction that's worth getting. And so you do that by working with them, educating them, and telling them when there's just not sufficient evidence to proceed. Anyone else? Thank y'all for coming. Appreciate it. Those of you in the media or who want copies of the documents, I have them up here for you to take home. Thank you.